Now, Mariam asked, is an employee bound by law to give notice of termination or notice of resignation to an employer before she or he can effectively resign her job? The notices of termination, which are required by law, are specifically provided for by Section 58 of the Employment Act. Now, Section 58, subsection 1, has this very, very specific provision on who bears the duty to provide notice before termination. And I will read it for you. Section 58, subsection 1 reads, a contract of service shall not be terminated by an employer unless he or she gives notice to the employee, except. Now, the law goes down to give two exceptions through which an employer can terminate a contract of employment without giving notice to the employee. Now, by reading Section 58, subsection 1, it is very, very clear that the notice of termination is the duty of the employer and not that of an employee. I will come back to it. Let me go to the next section, which causes the biggest trouble when it comes to interpretation. Now, Section 58, subsection 3 of the Employment Act provides that the notice required to be given by an employer or employee under this section shall be, and then it goes down to give the different lengths of notice that are applicable to different lengths of employment. Clearly, Section 58, subsection 1 is the section of the Employment Act that creates the burden to give notice, while Section 58, subsection 3 prescribes the length of that notice. Now, because the law included the phrase by an employer or employee, very many lawyers and very many employers misconstrue Section 58, subsection 3 actually create a duty to give notice on both the employer and the employee. This is incorrect. Legally, this is incorrect. As I have explained, the section that creates the burden of notice is Section 58, subsection 1, and it imposes that duty only on employers and never on employees. Now, the inclusion of the word employee in Section 58, subsection 3 is simply superfluous. If you read this section, it says that the notice required to be given by an employer or an employee under this section, it means that while 58 subsection 3 gives the length of the notice, the duty of the notice under this section must be looked for elsewhere within the section. And as I have already told you, Section 58 subsection 1 prescribes in no uncertain terms where that burden of notice lies. So the Employment Act, Section 58, does not impose the duty to give notice on an employee. That duty is the burden of an employer. Now, there is a public policy rationale behind the provision of Section 58, subsection 1. There is a very, very, very important reason why Section 58, subsection 1 of the Employment Act imposes a duty to give notice on an employer and it does not do the same on an employee. The public policy rationale is that there should be free mobility of labor, and the second public policy rationale is the improvement of livelihoods, career development, and improved incomes. Now, improved incomes definitely have a very, very, very big bearing on improved livelihoods. So, the reason why the law requires notice to be given by employers and not by employees is because public policy requires that whenever an employee has an opportunity to improve his or her income through alternative employment, he should be or she should be free to move to the next employer without suffering clogs of notices that may unreasonably keep her tied to the former employer. So the law has at its back a consideration to enable employees free to move from one employer to another for better employment without having to suffer any reprimands, any clogs, any hardships. If the requirement of notice was to be imposed legally on employees, it would inevitably negative the public policy rationale for free mobility of labor and for improved livelihoods. Secondly, if employees could not resign their jobs other than by giving notices as are required by the law on employers, then it would mean that no employee would be free to take up better employment when the next employer is not willing to wait for them. Because the requirement of notice on the other side would inevitably bar the employee from freedom moving to the next employment. And lastly, if the requirement of notice was working against employees, it means that an employee who is violated within the employment relationship would find it hard to run away from the violations without satisfying the requirement of notice. An employee would be tied to an abusive employment relationship by the requirement of notice, say 3 months notice or 2 months notice or even 1 month's notice, and would be unable to move without risking suffering court action. So the makers of the law found it important and reasonable, and it makes very good sense that the legal requirement of notice is a burden to be met by employers and not by employees. So now, nearly all employment contracts in Uganda simply transplant the notice periods provided under Section 58, subsection 3 of the Employment Act and place them in the employment contracts and make them applicable to both employers and employees. Technically and legally, that is wrong and that is illegal. The question is, what do you do if your contract of employment provides that you cannot resign or leave your employment except by serving notice periods or by paying in lieu of those notice periods? Are you tied to your employment? Must you respect those notice periods? And the answer lies within Section 27, which I explained before I went into all this. So, by Section 27, if an employer places a burden of notice on you in your employment contract, it means that that employment contract is void and of no legal effect. And this is exactly why I brought Section 27 within the answer that I prepared for you, Miriam, and others. So if notice periods are transplanted and placed in the employment contract with the effect of applying to employees as they apply to the employer, then that provision is null and void and of no legal effect. Therefore, if you want to resign your job and leave your employer, note today, going forward, that the requirement of notice does not apply to you. You can leave your employment when you want, how you want. The law does not require you to serve any particular notice or to pay in lieu of any particular notice. However, and I always say this, serving notice is good manners. While the law does not impose a duty on you, it is good manners to always ensure that whenever you are employed by anyone, when you are leaving that employment, you go ceremoniously. Because just in case you want to come back, and experience has shown that sometimes employees want to come back at a later stage, the door that you left smooth will receive you smoothly. But if you leave acrimoniously, then that will be imprinted on your record, and you might find it hard to return because you will not be in the good books of your employer. So if you can, it is good manners to serve notice or to pay in lieu of notice, simply to keep a good relationship with your former employer. But if you are pushed to a situation where you have to choose your next employment or whether to choose the withdrawal of your labor, if you are pushed by the employer to such a level where you have to choose to either stay in a job you want to leave or serve notice or pay in lieu of that notice, turn your face to the exit door and just leave. You do not owe any legal obligation to serve notice or to pay in lieu of any notice of termination of your employment. With that said, I hope Miriam and others have perfectly understood this. I thank you for listening. I thank you for listening to me. May God bless you.